Hello and welcome to this webinar from the Consent Collective. My name is Dr. Nina Burrowes. I'm the founder of the Consent Collective, and we were really keen to bring you this webinar on understanding the victim's right to review. This is part of our Something Good from This project, which is a project that's kind of born out of doing this kind of work. So if you're somebody like me and you've collaborated with criminal justice systems for a significant amount of your career, after a certain amount of time, you find yourself wanting to set up projects like this because whilst you're keen to help systems improve, etc., you can't help but notice that the cracks in the system are causing a lot of problems for a lot of people. So we're going to talk about some of those problems today. With me, I've got Kate Ellis, who's a solicitor from the Centre for Women's Justice. Hello, Kate.
Hello.
And we've also got Rebecca, whose story was recently featured in The Guardian, and she's here today to kind of help share her experiences of going through this process. So thank you so much for joining us.
Hello, thank you for inviting me.
It's great to have you here. And so for those of you who are listening in, just to reassure you, we cannot see you and we cannot hear you, so feel free to be chatting away with your colleagues and friends in the background. If you want to ask a question on the screen, I think on the right-hand side for you, you'll see a little question mark icon, and that's where you can type in a question if you want to. What we're going to do with the webinar is the three of us are going to have a discussion about all of these kinds of things. We're going to go through the process and talk about the victim's right to review to start with, and then nearer the end of the webinar we're going to get into but how do you live with decisions like this. And so that's the plan, and then we will get round to answering questions if you have any, and if we've got time to answer all of them. So to start with, the victim's right to review. Kate, can you tell us like what is it, and what is it designed to achieve?
So when you make a criminal complaint to the police, either the police or the CPS will make a charging decision, so they will decide whether to prosecute that complaint so that it can go to trial. If a decision is made by either the CPS or the police that your case should not go forward and it should not go to trial, either because there's insufficient public interest or because there's insufficient evidence, then you are entitled to apply for what's known as a victim's right of review of that decision. And the purpose of it really is, in the olden days, if a decision was made that your case couldn't be taken forward, you could challenge that in court. And there were some cases where individuals tried to challenge it in the courts. The courts developed the idea that a victim has rights, like they have a right to know why their case hasn't been taken forward, they have a right to challenge that, and there should be an effective mechanism for that. So as a result, the police and the CPS have developed their own internal mechanisms that are supposed to mean that instead of you having to go to court every time you disagree with the decision,
right,
you can challenge it through their internal kind of complaints procedure, if you like.
So it's supposed to be more efficient and
yes,
better.
Yes.
And we could have a whole conversation, of course, about whether it is and all the rest of it. So in terms of using, like, how is the system supposed to work? What does the process normally look like?
Well, when the police or the CPS make a decision not to proceed any further with your complaint, they have to notify you of that decision very quickly. They're supposed to inform you of any decision not to proceed within 1 day of them making that decision internally. They're supposed to give you their reasons, at least in summary, for doing that. And they're supposed to explain to you that you have this right to go into the review process. So you then have to think, do I want to find out more about the reasons, and do I want to put forward my reasons why I think their decision is wrong? If you decide to do that, you need to act fairly quickly.
Okay. So there's a time limit for you to do this?
There is, yeah. They usually say preferably within 5 days, and that it will very rarely be allowed after 3 months. So it's often a good idea to just respond quickly when you get the letter saying, I am going to seek review.
Which to me makes sense for the process, but Rebecca, I'm assuming like you've just got massive news, like something isn't going forward that you are like massively invested in, and I'm just imagining being emotionally able to respond within 5 days to, you know, something that maybe feels like it's full of legalese and stuff. Like, what was your experience?
So my experience when I was told the decision not to take the case to court I was told in person by the CPS.
Mm-hmm.
That was because I had a very supportive investigating officer.
Yeah.
And I did have a meeting with the CPS prosecuting lawyer.
Mm-hmm.
And they said that they would send a letter with everything contained. Now,
Okay.
when you get that letter, believe me, you're in no fit state to really process it.
Yeah.
If you're not already traumatised
Mm-hmm.
through what's happened to you, through the decision.
Yeah. To then see the reasons for a decision that you perhaps can't possibly understand.
Yes.
And to get it. And so how might people be able to resource themselves in that moment with the emotional side?
I found for me, because my family, my close friends were aware of what happened, I was able to reach out for that support.
Yeah.
If you haven't got that support, I can't imagine how you might go about getting some support for yourself. But certainly if you've got an ISFA, I would be leaning towards getting some advice from somebody who knows the process and knows the system.
Yeah. So Kate, if you do want support, this has happened to you, you know you have to respond. What are your options? Is it something that you can do on your own actually quite successfully, or is it going to be so much more successful if you've got backup?
I think it's helpful to have support. I mean, this isn't meant to be an overly legalistic process, but it may well be that the decision you've received is not just a case of have they weighed the evidence for and against correctly, but they might or arguably have not followed their own policy or the law. So it is worth getting some advice from an experienced ISVA if you can, and if possible, legal advice. It can be difficult to get legal advice because there aren't a lot of lawyers that advertise that they will offer legal advice in this area, as far as I'm aware. There can be, in some circumstances, some limited funding available for it, but not in many cases. And for many lawyers, it's not always sustainable to do this work. But we'll talk more later about services we might be able to offer if anyone wants to come to us who's really looking for legal advice.
Yeah, and we've got some information to share in terms of if you want to do this yourself, then here's some stuff that hopefully will support you with that. And so if we get into the process a bit, so we've got some information there that we're sharing with people in terms of how the victim's right to review works. So what let's have a look at this slide. So what information can you ask for before deciding to go through with this process?
Well, you're entitled in the decision letter to have been given reasons why they haven't prosecuted. In my experience, increasingly, complainants are often being told there wasn't enough evidence, as if that's kind of a breakdown of their reasons, which is not enough.
There's a catch-all.
And I think although it's not very clear in law, there is certainly an argument to be made applying guidance around this issue that you're entitled to more information for that. So the first thing you can do is you can respond to that letter and say, hang on, you haven't given me enough information. What evidence are you talking about?
Yeah.
They won't give you everything. They won't give you, for example, a summary of the suspect's interview in detail.
Sure.
Because there's certain information that they say, look, if you were successful in a victim's right to review process, it would jeopardise the trial if you knew too much about what other witnesses had said or other parties had said. But they can give you reasons about anything that they thought undermined your account, what evidence they considered broadly, and they should be giving you that. So the first thing you can do is go back to them and say, if it's not clear from their letter, what was the decision to prosecute based on? Was it based on there not being enough evidence, or was it based on them thinking that there wasn't public interest in prosecuting? Can they give a bit more information?
Disclosure is obviously quite very topical at the moment. So would that fall into the there was insufficient evidence?
Yes, absolutely. So I think quite often decisions are being made not to prosecute when evidence has been considered from a complainant's mobile phone, for example. There's text messages either with the suspect or in relation to, previous relationships or anything to do with their character, their credibility, that are motivated reasons not to prosecute. I think in this digital age that is becoming more and more common as a factor.
And what if it didn't even get that far? What if the decision not to go further was really early in the process and the police didn't even question suspect, like those kinds of procedural things?
Yeah,
what
well,
are your options there?
In those circumstances, you might be wanting to submit, if they've told you that they have actually reached a final decision not to proceed with your case,
Yeah.
you don't want to lose the opportunity to apply for a victim's right of review through the police. So I think you can write to them and say, I want to apply for a victim's right of review, but I also want to complain that you have not done X, Y, Z.
Right. So this part of the process has not been, which is really hard, because how do you know what they're supposed to do? Like, as you know, as the person going in and making a complaint, you're not an expert on what should and should not happen.
I mean, of course, it's helpful if you can get a lawyer to look at it, but I do think a lot of it is common sense. You know, we get a lot of people who come to us who say, it just really seemed to me that they should have asked the friends who were there that night who can comment on, I don't know, my capacity and various
Right, so they're like key witnesses, and I know you didn't even talk to them.
Yeah, so I think trust in your instinct, just because they're the professionals doesn't necessarily mean they've got it right.
Yeah, totally. Yeah, I think that's probably an excellent piece of advice, right? Right there. And what if, because we talked about that window of time that you're supposed to respond by, is that non-negotiable? If the time period is passed, that's it, you've lost your opportunity?
No,
or are there
not.
circumstances where you could still go through this process?
Yes, there are. So the 5, they often say they prefer you to do it within 5 days, but really the 3 months is the kind of slightly harder deadline.
Okay. And if that 3-month one is also passed?
If that 3-month one is also passed, you're obviously in a better position if it's only just passed than if it's passed by quite some margin. But I think in any circumstances, I think you should write to them. I think you should put forward your strongest case on the evidence and say, I think that you should consider reopening this. We had a case recently where we were admittedly not too far out of time, but we were a week or so out of time. We wrote on behalf of the client, and they didn't take an issue about it.
And so if you're sitting there, and this is perhaps something where the 3-month deadline is perhaps long gone, but maybe you just weren't in the right emotional space to do this at the time, but you find yourself now, it's worth writing a letter?
I think so. I think you just need to manage your own expectations to some extent, because
Yes.
if you are far out of time, even though it's completely understandable, if you write that, even if they decide to reopen it, your chances of getting a charging decision have probably decreased, because they, on top of anything else that they thought at the time, they may now say, this is now quite a cold investigation, and they may say that it's difficult to contact those witnesses or whatever the case may be. So just bear that in mind, but it's definitely worth writing a letter if you feel like you're in the space where you can do that now.
Okay. And Rebecca, were you able to draft these kinds of letters? Like, was it easy for you to do, or did you?
Absolutely not. I had no clue really where to start. I'm quite a pragmatic person usually, and my mind was in a state of chaos. I would say my mental health was very poor at the time as a result of this decision. Going back to my point about having support with family, I was in a very lucky position that member of the family is a criminal defence lawyer, and his partner has worked in the Crown Courts for years.
Okay.
Had I not had that opportunity to tap into that resource, I really don't think I would even have made the progress little progress that I made within the VRR.
Yeah. Yeah, I think those, like having a lawyer in the family, having somebody within a network. I mean, that's a big strand of how we feel about things in terms of something from this project, like how important it can be to help somebody, to help you navigate this kind of space. And I imagine for them it's quite simple stuff, but if you're not a lawyer, I think sometimes this kind of language is designed to it feels intimidating, even if it isn't designed to be intimidating. Okay, so if we move on through the process, we talked about writing letters and those kinds of things. What kinds of things are supposed to happen next?
Well, the procedure and the exact process will depend on whether or not you're going through the police VRR process. So again, that's when the police have made the decision not to take any further action, or whether you're going through the CPS's process, because they have slightly different procedures. They should tell you what the procedure should be, but broadly, with a police VRR, it will be reviewed by someone who is different from the original person. Different police forces have different policies, but usually it will be someone who's more senior who will then review that decision, and they will come back to you with their decision. You should be given updates to confirm that it's been referred up to them, and then they should tell you when they've made their decision. that process, if it's a police VRR, is usually fairly quick, I would say. They don't usually dwell on it for a very long time. You're not looking at months, you're more looking at weeks.
Mm-hmm.
The CPS procedure can take a bit longer, just from my experience, and also it is a 2-stage process. So what will happen if you write to the CPS to say that you want to apply for a VRR, they will refer it first of all to what's called the local resolution stage. So it will be referred to someone within the same CPS office locally to look at the decision again and decide whether they agree with it.
Mm-hmm.
They will notify you whether they agree with it or not. If they agree that the original decision not to prosecute was correct, you have an opportunity to have a second bite of the cherry. So it then gets referred up to a National Appeals and Reviews Office, which will look at it afresh again.
Okay.
And that review process is meant to be a fresh assessment at each stage. They're not just meant to look at whether the original prosecutor, was rational in their reasoning. They're supposed to say, look, was there anything else they could have considered? They might go back to the police and say, did you investigate this line of inquiry? At least, they are supposed to look at it holistically and fully all over again.
And how, if you're using this process, how do you know if they're doing a good job of this process yourself?
That's a good question. If you have a good relationship with the police officer in the case, sometimes they're kept informed as to what the CPS is thinking about. They may have been contacted to ask, did you consider this line of inquiry? Have I got this right? Have I understood this right? What is your view on this? So the police officer in the case may be able to give you some kind of lowdown informally on that. But the other thing is just the decisions that they give in their letters. And you should be able to scrutinise that. So, for example, if in the... So often at each stage you'll get more information. Even if it's a no at every stage, you might get more information at each stage as to why they're saying no. So at the local resolution stage, you might get more information than you did in the original letter. You can go to town on that letter. You can write again when you appeal it to the independent national office and say, look, not only did they say this in my original decision letter and I disagree with this, but I really disagree with what this person who's looked at it again has said. And you can, if you want to help yourself to do that, and you've kind of got the energy to do this, you can look up the CPS, let's say if it was a rape complaint, you'd look up rape and sexual offences. Their legal guidance is all online, so it's all supposed to be transparent. You can pick out sections that say things like, you should have looked at this type of evidence, or when you're thinking about consent, you should be looking at whether the suspect was reasonable in their behaviour. You can pick out all of these things and then use them in your letters to say, I don't think you've thought about this because the suspect did this, the suspect said this, I've got this evidence. You can use that. It can be difficult if you've got an ISVA who can help you tie that all together when you're in that kind of headspace. That I think that's probably really helpful.
And all of that, whilst you're talking, it's just making me realise how useful it would be if ISVAs were really supported to do this as part of the work as much as possible, because to me it really seems like a kind of space where having some kind of support and guidance would be essential. And even if it's just to help you emotionally kind of navigate this terrain whilst it's ongoing, that would. So if you're an ISVA listening and you kind of recognise that this is something you want to know more about or you want more training on, then please note that and pass that wherever it needs to go. So the Centre for Women's Justice does training on this, and what we do is we're recording this webinar and it will be live on the Consent Collective website forevermore, and we put a load of resources on there and links and all of the rest of it. So if we've skimmed over something that is more nitty-gritty, then hopefully a lot of that material will be available later. Plus we totally give ourselves permission to do another webinar on this and many, many other things. Rebecca, how did you, what was the process that you went to? Because it isn't just this process of writing letters and all the rest of it. There's also meetings involved in this. And how did you find getting to meet the people that had made these decisions and to meet the people that were reviewing these decisions useful or not in your case?
First of all, I'd say that it's very therapeutic if you do it's part of closure as well, and it's your shot at possibly somebody making an alternative decision.
Is it closure because you're like, well, there's just nothing else I can do? Or is it closure because it feels like it is a useful, I understand now, and this is a calm ending?
No, it wasn't a calm ending. I would say actually it threw up a lot more questions.
Yeah.
But it is your opportunity to be heard, because I never met the prosecuting lawyer prior to any of this, so they've never met me. They'd just seen, obviously, the statements or the evidence that the police had presented them. I would just say that, if you do engage with the VRR, just be prepared for the decision to stick, kind of manage your expectations, but you're in with a shot. You're in with the opportunity to actually ask questions, and get them to be held accountable.
Yeah.
They will skirt around certain things, and it's your opportunity to try and drill down and nail what they're really talking about. I found that I was thrown a lot of legal jargon. Again, it's your state of mind. You're not going in there calm at your best. You're going in there very, very emotional. So I would just say if you can bring a +1 with you, please do.
So you're allowed to take somebody with you, and it's a good idea. And if you happen to have a friend in the family who's a lawyer, then they'd be a good choice, eh?
But I would say word of caution there is this is going to be on a very sensitive and personal topic to you. So whoever you take with you, you need to feel as comfortable as you possibly ever can be. The CPS are going to throw some quite explicit things at you. It could even be about your character or explicit messages or anything. So just bear that in mind. Yes,
because often the reasons that might be used for not continuing with this case might be really personally very difficult to hold. And this is something that I'm super sensitive to and interested in, because a lot of my work is around rape myths and these kind of misconceptions, and this idea that as a victim of this crime, there was something that you did before, during, or afterwards that somehow makes this case less viable. And I think, to me, that is one of the instances where this kind of process can be, I imagine, so much more painful, because we're not going ahead with this, and it might feel like it's your fault. And I want to use this webinar to push back on that as firmly as we can. This kind of victim blaming kind of language, or like loads of things, like whatever it was, whether you were drinking, whether you've given a couple of accounts and they don't quite tie together perfectly, and they're worried about what a jury's going to think. Whether you had consensual sex with the same person afterwards or before, or whatever it is, often the reasons will be around this, and that really sucks. And so, Kate, when that kind of thing happens, is it we don't think the jury will believe this, or is it we don't know if you're credible because of this? Do you see patterns in terms of how rape myths are used to justify decision making when it comes to these things?
I think so. Some letters will be worded more carefully than others. Some prosecutors will be more careful in their meetings, but often the theme that comes up is, we believe you, but we're not sure if a jury will. A jury won't understand necessarily. A jury won't have had experience with victims before. Incidentally, they're not supposed to take that approach.
No.
And so the ones who are a bit more savvy may be a bit more careful about showing that they are looking at it that way, even if we suspect that they are. It is legally wrong for them to just be predicting that because juries don't often convict in cases where the issue is consent, that means that that's the test they apply. They should be looking at it as, okay, we are smart people, we know victims, we know that victims may not always give, for example, entirely consistent accounts of what happened, but we can build this case. That's the approach they should be taking.
Yes.
So you really should push back on that.
And how do you push back? What exactly do you do? Is there something you can specifically refer to and say you're wrong for making this the reason because this is how it's supposed to be?
Yeah, there is guidance which we can circulate after this online. I mean, in a number of different for a number of different audiences actually, but the CPS's own online guidance includes a list of what they call rape myths, and sort of myths and assumptions about how rape victims behave and the circumstances in which rape and sexual offences happen. That can often be really helpful, because if they have said something like, for example, a jury would be really concerned that you went back to your abuser in the context of a coercive relationship, and had consensual sex afterwards, you can highlight that is a rape myth. If it was said, a jury would be really concerned that you were drunk, at the time, that's another thing which is a myth. So it's kind of, you can refer to their own guidance and use it against them, as it were, either when you're just talking to them informally in the meeting or in your letter to challenge the decision.
Yeah. So if there's anything along the lines of, the jury's not going to buy this aspect of the evidence, then that's exactly something you can challenge them on.
Yes.
And Rebecca, in your case, it was rape mythtastic in terms of, if I remember rightly from listening to your interview, in terms of they didn't think you seemed traumatized enough, which is absolutely disgusting to hear from somebody working in the criminal justice system. And also, I don't think, I think a decent barrister can help a jury understand these kinds of things. As somebody who studied rape myths a lot, if we basically say, oh my goodness, any case that's got any kind of a rape myth in, it shouldn't go forward, the courts would be pretty quiet, because this stuff is kind of everywhere. But
it should be said as well, we won't go through everything, but another common one that comes up, less and less you might see the really obvious ones, like, what she was wearing was provocative or something. But we do see a lot that effectively come down to you didn't react quickly, you didn't fight, and that is absolutely a myth, and something that you should hold them up on with reference to their own guidance. Yeah,
totally. Yeah, and I think that kind of that personal bit. One of my frustrations with my work is that I get the opportunity to go in and talk with professionals in the system about rape myths and all of these things, and most often people don't fight or offer resistance. Most often people don't report straight away. In fact, most people don't report, full stop. And so it's really frustrating that a lot of this information isn't automatically passed on to people who are in the system themselves, to help them understand their own behaviour and their own reactions, because I could just imagine the situation where you have the courage to report and then you find out it's not going forward, and there's a suggestion it's because of you. And if someone doesn't help you understand your own trauma responses, your own, however you respond to something that isn't supposed to happen, as in sexual violence, that's how you respond, that's your coping mechanism, that's you in the moment, it all makes sense somehow. And no one should ever point that at you and say, oh, this is the reason, a jury won't believe it. That's just, okay, I'm going to get off my soapbox for a second.
I found that both the lawyers, so the original prosecution lawyer and then the acting deputy head that I had the first VRR meeting with, they were not trauma informed at all. They when they questioned my response, I actually asked them can you give me 2 typical responses to trauma?
Yeah.
And the room was silent. And you would think for a RASO, a trained lawyer, they would know a typical response to trauma, and they were nonplussed. So
if you want to test out in that meeting, where is this rape myth coming from, you can actually challenge them on it and see if they do understand the difference between the myth and reality. Because if they're not able to explain how trauma works and all these kinds of things, then okay, this is what you think juries think. This is more about you and your understanding of these issues too.
From a kind of cold hard lawyer's perspective as well, it's always great if you can either note down or get that +1 who's with you to take a note of what they're saying, because often they do let things like that slip, and you can then use that against them in anything that you write. Are
you allowed to audio record the meetings, or is that not allowed?
Technically you should ask them, and they may say no, but I know people who have done that. I think it's excusable, and I don't, you're not going to get in trouble for doing it. They just may not like it.
Or ideally take somebody with you, and even if that person you know, that their one job could be just to take notes, because
Yeah.
it's very likely, especially, you know, with the emotions and the trauma and everything else, you might not remember a lot of the meeting afterwards. And so you need somebody there to take a note of what happened and be there for you in that way. And of course, like, not everybody in the world's got a lawyer in the family. I don't. And so if you really feel like you're on your own with this, is the best that we can say is, right, there's information, we will put links. It's about equipping and empowering yourself as much as you can to do this.
I think if even that feels too much, if you're feeling like, you know, I'm going to have to write this letter referring to section this of this legal guidance and case this about this, and it just feels too much, that's completely understandable. I think there are practical things you can do. Trust yourself. I mean, I really do want to say that. We get a lot of people who say, I don't know the law, but this feels wrong. Say it if it feels wrong. Say, I don't think you've assessed the evidence in a way that's rational or reflects the way that women in my situation feel. Talk to other people, talk to that +1, talk to friends, because sometimes, you know, if you can trust them talking about your case, if you feel able to do that, they might come at it from a sort of objective perspective and say, hang on a second, you know, how have they missed this? And, you know, and again, we'll circulate information about contacting us. We can't often offer like one-to-one support, but we can help refer you to people and find out about ISFA services in your area. We were talking earlier about, you know, mixed experiences of ISFAs in terms of how much they know and how proactive they are. But you might well get someone who's really helpful, or at the very least can do the kind of legwork of putting what you're saying into writing. Yeah.
And is it the case that cases are so nuanced and so different, having an example letter isn't very helpful? Or do you have resources like, oh, here's an example letter, just to help you understand the kind of language to use?
Yes, we do. We can make that available.
Okay, so those kinds of things are totally there. What if, as going through part of this process, you're like, because we're talking about the victim's right to review, so we're still very much talking about the criminal justice system. Like, are there options outside of this? If you want to, like, what are your options in terms of using the civil courts, or maybe you want to get a private investigator to, like, investigate these things? Is that could that be a useful direction to go in if you've got, you know, the resource to do that? Resource, not just, you know, the money, but also the time and the emotional space and all of the rest of it.
It's very interesting. So in terms of taking a civil action against the person who assaulted you, say, or committed the crime against you, as far as I'm aware, there's not much precedent for that, but it's a very interesting option. There is the possibility of doing that, and I would say if you are thinking of doing that, look up lawyers who do kind of personal injury cases, particularly firms, I guess, that have a kind of human rights backing, or come and talk to us. We might be able to help find you someone who's got that kind of area of specialism where they may really know their personal injury stuff and be able to think outside the box about taking a novel action like this. So it could be something to consider. Private investigators, you know, that there is always the option of private prosecution, but usually it's not worth going down that route, because what can happen is the Crown Prosecution Service, if they become aware that you're doing it, really frustratingly can take it over and either say we're going to continue it ourselves, or in most cases where they've already turned down the option of prosecuting it, say again, sorry, we're going to shut this down. It's a really frustrating kind of block in the system. So what I would say is, if you've gone through the victim's right to review, I always get that wrong in the back of my head, victim's right to review process, and you've been unsuccessful after all stages and you feel like you're at the end of the road, you are not necessarily, there is the other option of seeking a judicial review of the decision not to prosecute by the police or the CPS. So a judicial review is a procedure that you take in the civil courts. It's what we call a public law procedure. And it is basically saying the decision was unlawful in some way. They are difficult cases to win because the courts often... so first of all, you have to go through the victim's right to review procedure first. You can't say that the original prosecutors got it wrong, so you're going to go straight to court.
So you have to test it by using the process.
You have to go through the process. Then after that, you know, the courts do often look at these as like, well, these are specialist prosecutors who really understand these kind of cases. We don't want to override their expertise. But it is worth getting legal advice about. It's something you can contact us about if you're finding difficulty finding a lawyer, or you can go to the Law Society and say that you need a judicial reviews lawyer to look at your case. You need to act very quickly because there are time limits on that as well.
Right.
And in fact, if you're midway through the VRR process at the moment, if anyone listening is, consider getting legal advice now so that you're kind of ready if you want to take advice and consider a challenge. And it does happen that in some cases you can challenge it, particularly where it's not just about, them having ignored relevant evidence, but it's actually a case of they've explained, for example, consent in a way that is not really compatible with the way that's defined in law. So if they've made a kind of legal error in the way that they've reasoned it through, a lawyer might be able to pick up on that and say this is worth a shot.
I feel like part of this webinar, there's almost a dance between not setting people's expectations too high, because the truth is what can be achieved is limited.
Yes.
And the support available to help you even achieve the best possible outcome under these circumstances is limited, and time is limited. However, there are things you can do. It might be useful to go through this process yourself in some kind of closure, kind of cathartic way. I think it's useful to get things in writing. I think it's, I'm kind of curious, like if we think how many people this has happened to, like how many people don't have their cases go forward. So how many letters are there out there in England and Wales where they've written down, these are our reasons not for going ahead with your case. And like that information is there. And that to me is that it does give the opportunity to, hold systems to account when they have to write down their reasoning, even if you can't do it like in the moment. But it is hard to, I guess it's always that dance about not setting people up to fail. So Rebecca, in a way, you got a result. Like in a way, you're like do you feel like a victim's right to review success story because you followed it, theoretically to the end?
I've made them feel very uncomfortable
throughout
this process. And what I would also share with you is that I didn't just involve them. I involved my local MP.
Yeah.
I wrote to the Director of Public Prosecutions. I wrote to the head of the police, my local area police force. And I also wrote to Baroness Newlove. So anywhere they went, I was putting it out there, and I would put on the letters CC.
Yeah.
To make them...
Anyone can write to their MP, anyone can write to the Victims Commissioner, and we can put some links through to help you do that. But like I know from personal experience, like MPs tend to get replies to letters, whereas their constituents tend not to get replies to letters if you're sending them to senior places. So do engage your MP. It is what they're there for.
Yeah, I had a meeting with my MP. I would say he was helpful to a point.
Yeah.
He was able to get a response from the Director of Public Prosecutions, which I wasn't.
I've never been able to get a letter out of the DPP, so...
However, she was very detailed in that letter about my case to my MP, which again I thought was...
Okay.
Just so if you are going to involve other people, just make sure you're comfortable that a response might go directly to them.
Yes,
about
okay,
your
so
case,
just
just
being
to get
aware
that out
in
there,
terms of
yeah.
your own boundaries that you're opening it up and opening it up, the more you want to make noise.
Yeah.
But that if that feels like it is a good option for you, that's certainly possible. And I guess, so part of this webinar is also, it's not so much, what's possible if you work with the system. I'm really interested in how can people adapt to this kind of decision making, given that it can have an absolutely massive effect, a massive emotional effect. And also those of us working in the system, like Kate, I'm curious about, I assume you got into the law because you care about justice and these kinds of things, and then to hear that systems are failing so many people in all these different ways that just don't feel like they should be failing for, if you like, better reasons than some of these simple ones. Like how do you do what you do and keep doing it?
Yeah, it is really frustrating. I feel that a lot of what I do, which might sound a bit of a strange definition of a lawyer, but is allow people to absolutely exhaust the process and get as much closure as they can possibly eke out of the system, even if that's not as much as it should be. So I do feel like a lot of what we do is saying we can't fix the system straight away.
Yeah.
But do you want to keep pushing on this? Because we'll keep pushing as much as we can. I think the other thing is that a lot of what we do ends up feeding into kind of strategic questions that we can raise about the system, and I won't say too much because you can kind of look on our website and find out more, but it is really, really important to hear people's stories, and we often do kind of encourage people to exhaust the process if they feel able to, because what they learn from it may feed into kind of our wider work. But it is that balance, as you say, between kind of what's best for people's health and well-being, and what's not. When you are thinking about sort of making an impact and raising awareness of your case, which is what a lot of people who come to us kind of feel like they want to do, is like, say, this happened to me, it wasn't fair, it must be happening to other women too.
Which is a correct assumption.
Yes, we are often really supportive of people to do that, and it really, really helps our kind of our work that we do, where we kind of raise profile of problems in the system, but we also have to be conscious all the time that you need to be checking in with your mental health and how you're feeling, and whether you're kind of up to continuing with this, or whether you reach a point where you think, I need to close the door.
I think that, if you like, some people wouldn't be comfortable with the word activism, and some people are like super comfortable with the word, but however you want to describe it, it's like, I've had this experience and I don't want anyone else to have to go through this, and I want change to happen, and I'm going to put some energy into that. I think doing that healthily is a real art form, and it's really important to not take too much on yourself, like to not think that you have to on your own change the world and that you're responsible for this now. I think it's important to know you can dip in and dip out, not do it all of the time. Rebecca, you chose to go public with your story.
I did.
Which I'm sure has had an impact. Has it helped you at all, or how's that process been? A different form of, I guess, trying to at least create change, if not experience a form of justice?
It gives you a voice. It also, when you see people's response to on social media, it also gives you a lot of moral support. It's also a very validating thing to do. A lot of the decision around the CPS, it puts questions at you, makes you question yourself as well. So having people who are interested and supportive has certainly, been part of the process, and it spurs you on to carry on that fight. Is my experience. It hasn't taken the energy away. It gives it back.
So you found it energizing, but it can't be for the faint of heart. It's quite a big exposing thing to do to put yourself out there. But there are like loads of examples of people who are increasingly willing to do that, and I think if that feels like something that could be, something you're interested in, and I imagine a lot of people there'll be lots of different people who'll be interested in this webinar, and one group of those people will be people like, I've listened to everything you say, and it's too late for me. Like, in terms of my case, it's done as far as the victim's right to review is. But I guess it's useful to know there are other ways. It doesn't have to be the end completely. There is activism. There is, and you can share your story in lots of different ways. You don't have to put your name out there. You don't have to do it. You can do it confidentially, and all of these kinds of things. But I know that can be really healing for some people. Do a lot of people who end up being involved in the work you're doing here at the Centre for Women's Justice, do a lot of people choose to go public with their story, or they're particularly wanting to be involved in cases? And
I think quite a few people do to some degree, whether that's going kind of completely on the record with their name, whether that's in more cases speaking to the press, for example, confidentially, either when they're bringing a case, or when they've kind of gone through the process. There's no legal remedy, but they want to go to the press. Other people also like to share, sometimes share their case stories to sort of support another legal challenge, or to support kind of to allow it to be used when anyone's kind of giving, for example, let's say that Parliament is looking at a particular issue, their case study could be kind of looked at as an example of the system failing. So I think there are lots of ways to do that. I do think a lot of people do. I think it's a decision you have to think about quite carefully. Obviously, if you're going through it confidentially, you are quite well protected. We do encourage people to think very carefully before going public with their name, because often a lot of people feel like they want to do that, like, I want to go on the record, I want to say everything, I want to be completely open and be me, and I want to be seen as me, I don't want to feel like this, like sort of faceless in some way.
Yeah.
And also, what have I got to hide, which is absolutely right, but from a practical perspective, sometimes they are overwhelmed by the amount of exposure they then get, the amount of people they get contacting them on every, bizarre and unpleasant messages as well, potentially. Employers looking that up, so it's worth just thinking through, like, what will this mean for me if you're kind of thinking of going formally on the record, and just maybe think about going on the record and anonymous, or off the record, on the record, anonymously, if that's an option. And a lot of journalists are very used to doing that if you are kind of wanting to have a media presence.
There are some good people out there, but of course for a lot of people they won't want to go down this path, but they'll still be interested in being part of change and trying to expose these systems when you don't think that they're working very well. There are lots of different kinds of perpetrators out there. What if your perpetrator is part of the very criminal justice system that is theoretically supposed to then investigate itself to see if it's done its job properly? Have you got any advice about that if the person who harmed you was a member of the police or somehow involved?
Yes, I would say at the outset, you feel emboldened to say, I want a different police force to be investigating this matter, because it may well be investigated within force, and that's not a good thing.
Okay, so that's something you're entitled to do. You're
Yes.
entitled to ask for an alternative.
Yes, they may say no. It's not like an absolute hard legal right, but really they should be referring it to
And when you say
force.
request, who do you send that request to? Like, just your investigating officer, or should you send that to somebody very senior within the force to make that kind of request?
You could send to the investigating officer to begin with. If that's then refused, you can write again. If that's then refused again, you can submit a formal complaint to the Professional Standards Department. I mean, my other main piece of advice was going to be, if you find yourself in this situation, do see if you can find a lawyer to help you, because you should be thinking of this in terms of, if this is not investigated properly, you've got potential misconduct in public office, you've got misfeasance on the part of officers. And I know that sounds very cynical, but sometimes it does happen.
Yeah. And would you be more likely to get that kind of pro bono support under those circumstances, or is that not necessarily the case?
Well, it's again a bit like getting legal advice and support in relation to the VRR process. If you are of fairly minimal means, lawyers can actually get legal funding for that, legal aid funding. Again, it's not substantial, it's not sustainable for a lot of lawyers at firms that kind of don't have the resources to do that, but it is possible, and there are good lawyers out there who will do it pro bono for you. Again, it's something the centre might be able to help with, because we have a few lawyers who are great, who will often do that kind of stuff on a voluntary basis and see where it goes. Yeah.
And we got another question in here in terms of going public, and some people are scared of being sued for slander, because if they do go public, I guess that can go both ways. So we've got the example of Miss M, currently up in Scotland, who was unsuccessful with the criminal justice system and then took out a civil case and successfully sued. So I guess if your perpetrator does attempt to sue you, of course you have the opportunity to prove that you're telling the truth in civil courts if they decide to do that. So it isn't necessarily bad news, but of course it's something to consider.
It's not necessarily bad news, but it is definitely something to consider. And the cautious part of me, while I always want to encourage people to go public if they feel they want to, is to say, do think about protecting yourself and not necessarily naming the suspect.
Yeah.
Obviously, if you are making a complaint against a high-profile person, then you may really want to name them, but absolutely get legal advice from a libel specialist.
Yeah, and I think there's a difference about going public about your perpetrator and going public about a system that doesn't work.
Yes.
And certainly in your case, Rebecca, it was your story is about the system. And if you haven't heard the interview that Rebecca did with The Guardian, it's not an easy easy interview, but like having heard it myself, and when you're working with these systems, like it does beg a belief, like if that kind of really overwhelming and compelling evidence isn't enough, then what is? And so there's a difference between going public about the person that did this to you and then the system that is not, you don't think is working effectively.
There is, and I'm not a libel specialist, but if you don't name the suspect, they can't, and you say nothing that can allow them to be identified, there's no problem there. If you do identify them, but your story is mainly about the system, it's a kind of contentious area of law at the moment, and following a recent legal case, it is arguably in the public interest and therefore defensible for the purpose of libel proceedings to say this person attacked me and the system did nothing. However, really get that libel advice if you're considering actually naming and shaming someone, because you are putting yourself at risk.
Yeah, totally. I'm conscious of time, and because I'm a psychologist, I do pride myself in my timekeeping and boundaries around that. And I'm also really conscious that like this is such a difficult topic area, and certainly like in my work, there's not too much of my work that's comfortable, but I find injustice, when I think about it, when I'm engaged in that energy, it is the hardest energy for me to sit with. I find it physically very painful to hear these stories and to bear witness to somebody else's pain around that. And so this has not been an easy webinar to put out there, and I'm sure it hasn't been a super easy one for people to listen to. And so I'm really conscious about, how do we end this in a way which doesn't feel too full of despair, and feels maybe healthy. And I'm curious, like Rebecca, like through this process, so you've been through a lot, and then the criminal justice system put you through a lot. What kinds of tips and tricks have you used to get through that and come out the other side as healthy as you can be?
I was in a very fortunate position that my employer I get private healthcare through them, so I have had access ongoing for 18 months to one-to-one therapy with a trauma counsellor, and I appreciate I'm probably not in the majority.
It's probably exceptionally unusual, but
it's exceptionally unusual.
I'm glad that you've had it.
But that has been paramount to, I think, just getting on with life as much as you can. I think it's really important to recognise triggers within yourself, and not to kind of knee-jerk react as in, I'm going to go and go down the pub.
Yeah.
The biggest piece of advice I could give myself and to anybody that's been through this kind of trauma is to try to look after yourself in a healthy way. For me, it was very much making the decision not to slip down that road of drinking into oblivion to numb the pain. Go lift some weights in the gym. Smash your hating the patriarchy out in there, and be kind to yourself. Don't take too much on. This is exhausting. Yeah,
absolutely. It's physically exhausting, emotionally draining, super hard to deal with, and it can also be like it's one of those things. It's about learning to live with it rather than necessarily. I always compare it. It's not a perfect comparison at all, but to grief, you don't really get over it. You live with it. You adapt, and then there will be moments in time where it's harder to do that, and there will be moments in time where it's relatively easy to do that. Kate, are you a great example of exercising fantastic self-care, given that you spend an awful lot of time thinking about sexual offences?
I guess so. No, I don't know what I'd have to add to that really, other than that's all really sound advice. And yeah, I think I think supporting people who, thinking of kind of ISPs and lawyers potentially who might be listening to this, supporting people can be tough as well, obviously not to the same degree. But yeah, I think just look for the ways that you can help kind of validate someone's experience, really. Because I know that Rebecca said that, and I think that is, if the system lets you down, at least having other people around you who are like, no, this is crazy. This is you're absolutely in the right.
To validate your experience, because this system it always feels to me, it's set up, it's designed to make you remain in isolation and hold that pain and sit on your own and blame yourself or whatever, but it's designed to maintain isolation.
Yes.
And I think whatever you can do to get out there and connect with people who get you and get this, and sadly there are many of them because so many people have had these experiences. So it's always a curiosity to me, like we provide one-to-one support, and if you go through the criminal justice system it's very isolating, and yet there's a massive community of people out there who will have had experiences that sadly won't be too dissimilar from yours. And so finding community where that's possible, I think, can be a really important part of this. And then, of course, having time out and all of the rest of it. I've got some resources for you from the Consent Collective to hopefully help you with that. So you can obviously check out us and the Centre for Women's Justice on Twitter. This is a screen grab from our Something Good from this page. So if you go on there, this webinar has been recorded and we will then put this webinar there. So if you've been listening and the connection hasn't been very good, you'll get a good quality version of this online within a few days when I've had time to edit it. So that will be there, and any future webinars that we do or events will be on that page. So that's the place to go to if this is your interest and you want to know more about this. We've also got a page on our website for people who want to be part of change. It's our champions page, and so if you're interested in just being part of change in whatever way, shape or form that works for you, then that's available. And I also want to point you towards my own work in terms of my book, The Courage to Be Me. Let's just see if I can work out the... Yes, so if you go to my website, which is ninaburrowes.com, you'll find on there, you'll be able to access The Courage to Be Me, and you can read the whole book online. And that book has got some resources in terms of understanding your own responses at the time. So like, why didn't you fight, and how does trauma work, and all of these kinds of things. So if you think that would be beneficial to you or the people that you're supporting, please do that. And as a final request, please just have a think about what you're going to do now. And do you need to phone your best friend, or do you need to go for a walk, or do you need even a cigarette, or whatever it is that you need? Please exercise a bit of self-care having listened to this. Keep an eye on the website because we will definitely be doing more webinars. And thank you so much for joining us today. Rebecca, is there anything that we've not said today that you want to leave as a final thought? And then Kate, I'll be coming to you.
Just lastly, be kind to yourself. This is, I said at the beginning, if you're more than likely to be in a state of trauma. Doing the VRR can be re-traumatizing. Yeah. So please be kind to yourself and please reach out for help. The last thing I would say as well is I'm a great advocate of employers supporting you. You don't have to disclose any of this, but if you do speak to your employer and explain that you're going through a legal process, I don't think you should have to take your own holiday to attend meetings with the CPS or the police. If you feel comfortable enough to speak to your employer, please ask them for special paid leave around this. So your holiday really is your holiday.
So if you're fortunate enough to have a decent employer, and if you want some support with that, again, go to our champions page, because a lot of that is really about encouraging employers to step up and support their people around these issues, including the criminal justice side of things. Kate, is there anything that you'd like to leave as a final thought?
Yeah, I think I have two very quick things about time. We had questions about how difficult it is to access support, whether that be counselling and ISFA legal advice, which is absolutely true. I'm sorry that I haven't been able to sort of put forward answers in this. I think it's a massive campaign objective, but also I think that what Rebecca said about turning to the people who are kind of immediate to you, like your employers and other people that you can turn to. It's not a substitute for counselling, but think about how people around you can better help you if they know what's going on. And the second final thing I think I would say is for anyone out there who is working with someone who's going through the VRR process, so if you are an ISFA or a lawyer, I find it constantly a learning curve, because you have to recognise that someone is going through a post-traumatic process, and you have to think about all of the ways that even you having asked them to reply to 5 emails in a day might have actually felt really overwhelming, and you have to check in with yourself all the time and think, am I supporting this person in the best way? So I don't know what I would sort of preach from that, but but all I say is that it's useful to kind of learn from your own
to
mistakes.
hold it, to recognise good outcomes. For me, a good outcome has to be centred around the well-being of the person going through the system first, and then the needs of the system, not even second and third, but it's on the list somewhere, maybe. And it's about being aware whether your own practice is at the service of the system or at the service of the human beings that you're engaged with.
Yes.
Okay, well, so thanks very much, everybody, for joining us. I hope you got a lot from this. As I said, if you want to listen again, or if you know there's somebody who should listen to this, and this webinar will be there in the future, so if in the future you want to send people to this webinar, it will be on the website. But for now, thanks very much for joining us today.